Mr. Chairman, distinguished colleagues, I am truly honored to address all of you in this immensely important forum, which I believe enhance judicial dialogue across the globe, and it really helps us to understand each other better. So thank you, Mr. President of the Constitutional Court of the Republic of Turkey, for your analysis of the role of constitutional courts in maintaining social peace. As a discussant of this session, I am responsible for fruitful discussions, and that's why I have prepared 3 short reflections, 2 questions to my esteemed keynote speaker, and maybe 1 question to each of you. So, my first aspect. Honorable keynote speaker emphasized that pluralism and diversity are needed and essential for a democratic society. Speaking about this aspect, I believe that starting point must be the concept that each person is unique, and society, which is based on the idea of freedom, is the most appropriate environment to realize ourselves. If we can realize our personalities in many different ways, we can contribute to the development of our countries. However, I can share the concerns of the keynote speakers that social diversity can affect social peace. Dealing with cases where some social conflicts are at stake, constitutional courts, in my opinion, have to bear in mind that, on the one hand, freedom of individuals must be respected, but on the other hand, national constitutional identity draws an ultimate line for proper balance. That means a person can exercise freedoms only within so-called the unchangeable core of the Constitution, and democracy should not function only in a way that this person or some group of society accepts democracy when its preferred opinion prevails. Individual freedoms, mentioned before, could be protected and balanced by the Constitutional Court dealing with the applications submitted by any individual person. Dear colleagues, since an individual type of application, and I mean constitutional complaint, is an effective instrument to protect human rights, constitutional courts actually have become the key players in ensuring so-called unity in diversity for the whole society. So, and that's why I would like to ask a question to my honorable colleague, keynote speaker. What could be the reasons why many legal systems across the world still don't embrace the idea to introduce individual complaints? Why so many countries don't use in their jurisdiction so effective instrument through which Constitutional Court can play significant role maintaining peace and social justice? My second aspect, I would like to touch upon question, what is the legal base for the constitutional courts to ensure social peace? Well, in essence, the members of the conference were asked whether the existence of precise regulatory framework for peace and reconciliation is the precondition for the courts to ensure it. Colleagues, in my opinion, the question of a precise regulatory framework does not play any significant role. It's because the necessity to ensure social peace derives from the values that are enshrined in our constitutions. In spite of the fact that regulation about social peace does not exist expressis verbis, such values as democracy, sustainability, human dignity, and protection of fundamental rights are those fundamental pillars that should guarantee peace and reconciliation in every situation. By interpreting the catalogue of fundamental rights in conjunction, a fair balance between competing interests could be reached. At this point, I would like to highlight in particular the conclusions made by the keynote speaker. Even if the majority of constitutional courts have not referred to the terms social peace and reconciliation, they have facilitated peaceful societal coexistence by ensuring and promoting such constitutional principles as separation of powers, rule of law, democracy, and human rights. Dear colleagues, at the same time, the constitutional courts should bear in mind that values enshrined in the Constitution as a legal basis, in my opinion, are rather broad and should be applied in a manner that ensures social peace, not dividing society. In order to promote discussion, I would like to ask my esteemed colleague again. Well, we can imagine a situation where politicians, due to lack of consensus, choose not to address a socially and ethically ambiguous issue. And just, for example, I could mention the question of euthanasia. So, should the courts rule on the issue which are debated in Parliament at the same time? If yes, how courts could avoid polarization and conflicts in society, as well as constitutional crises related to disputes over the limits of judicial competence? Dear colleagues, now I turn to my third and final point. Please take a look at the symbol of our Congress. It is a dove of peace and map of our beloved world. Right at the heart of our symbol is Ukraine, where a brutal war is taking place right now. Torture and murder of Ukrainian civilians are Russia's routine in this war. Since I have to talk about the application to the Constitutional Court, but not about war, anyway, I would like to ask this prominent audience, what kind of application the Constitutional Court of Russia is dealing with? The answer was given by the court itself, actually. Just for your attention, just 3 days ago, this court, violating international law, endorsed the annexation of part of Ukraine's territory. In doing that, this court has turned into a political institution for legitimizing the ambitions of an autocratic regime. and it does not truly care about the social peace, neither in Ukraine nor in its own country. Such a court, dear colleagues, is no longer a court in a sense of Article 1 of the Statutes of the World Conference on Constitutional Justice. The aim of this article, I mean Article 1 of our statutes, is to unite all world's constitutional courts which are truly committed to such common values as rule of law, democracy, human rights, and human dignity. If my dear colleagues from other continents truly believe that the Russian Constitutional Court still complies with the Article 1 of our statutes, then I would like to pose this question I promised. Dear colleagues, what else should happen in the world that could serve as a real ground for excluding an aggressor state's constitutional court from the world's constitutional courts family? Thank you.